This is a closer look with the Monitor on Prairie Public. I'm Craig Blumenshine. The proposed JETx transmission line took two significant turns this week. JETx is a proposed 92-mile-long high-voltage electric transmission line connecting substations near Jamestown and Ellendale through Stutsman, LaMoure and Dickey Counties, designed by Otter Power and MDU Resources, designed to improve the reliability and capacity of the regional power grid. On Tuesday, the North Dakota Supreme Court heard arguments from landowners and townships who say they were denied proper notice and participation during an earlier approval process. Then, on Wednesday, the North Dakota Public Service Commission unanimously approved the project's final route permit, clearing another major hurdle for construction. Well, joining us now to unpack all of this is North Dakota Monitor reporter Jacob Orledge and North Dakota Monitor now contributor Mary Steurer. Mary and Jacob, welcome back to A Closer Look with the Monitor.
Thank you.
Thanks for having me on, Craig.
You're sure welcome, both of you. Glad you're both with us. Mary, let me start with you. Let's start at that Supreme Court hearing. What's at the heart of the legal challenge brought by landowners and townships relative to the JETx transmission line?
So the landowners and townships have asked the North Dakota Supreme Court to find that the PSC didn't follow the law in part of their review of the power line. And some of the main specific things they said didn't happen is they didn't provide direct notice to affected communities about this part of the review, didn't gather enough research about the project and its potential impacts, and then didn't sufficiently present their findings to the public. So the Public Service Commission and then the two utility companies behind JETx say they did follow the law, but then another key part of their argument is that they say the plaintiffs missed the deadline to challenge the outcome of this step of the review process.
We'll talk more about that in just a minute. Jacob, I want to turn to you. While that case was unfolding, the very next day, the North Dakota Public Service Commission moved forward with the route permit. What exactly did the commission approve Wednesday, and why is that decision significant?
Well, the Public Service Commission essentially gave the project a green light on Wednesday. They approved a route permit for the JETx transmission line, and they are allowing the project to move forward, finding that the companies behind the project, Otter Power and MDU Resources, have met all the legal requirements for that permit, and the commission can't stand in their way.
Mary, the plaintiffs argued that they never had the meaningful opportunity to weigh in whether the transmission line was needed in the first place. Why do they believe that happened? Was that discussed in the court on Tuesday?
There's a part of the PSC's review process that's supposed to specifically look at, does the public need this transmission line? The utility companies need to apply for a certificate that says, yes, my project is needed. So while the PSC reviews this application, there's an opportunity for the public to weigh in. It's a little bit complicated, but when this happened for JETx, the landowners and townships say they followed the wrong procedure. So there are different ways the review process is supposed to play out that apply in different circumstances, and the plaintiffs in this case say the PSC utility companies used the wrong one, and that as a result, the public was not afforded enough opportunity to know about what was happening. They say the law JETx used only required notice of a hearing on this application to be published in the newspaper, whereas the plaintiffs claim that affected counties and townships and landowners in the path of the transmission line, I think, should have been served directly with notice of the hearing. Because they didn't get this direct notice, the plaintiffs say they didn't have a proper opportunity to speak their mind.
Jacob, the commissioners in their hearing on Wednesday repeatedly said they were bound by state law, and that was it. What concerns did opponents raise during the permitting process that the PSC said it couldn't consider?
You're absolutely right, Craig, in that all three public service commissioners emphasized that the applicants in this case had met all legal requirements for a routing permit, and that therefore the Public Service Commission had to give the project a green light. Commissioner Jill Kringstad, in whose portfolio this application and review process sits, There were many concerns brought by landowners and members of the public during the public hearing process, but most of those concerns fall outside of the Public Service Commission's jurisdiction and couldn't be considered. These concerns include everything from potential for the transmission line to be used to service data centers to threats of eminent domain against landowners who don't want to sign easements. Also, to the landowner's dissatisfaction with minimum setback requirements, in that these transmission towers have a minimum setback distance of 500 feet, and many landowners feel that is insufficient.
Jacob, let me continue with you. Even as the commission approved the permit, it did include some conditions. What protections or accommodations, if you will, were added for landowners and local governments?
Well, Public Service Commissioner Joe Kringstad did make the point multiple times that there are protections incorporated into the Commission's order, and some of those protections include dust mitigation strategies that the companies have to follow during construction and road use agreements, especially during the construction season. She specifically cited the need to protect farmers and their operations in the area of the transmission line's route as reasons for why those protections are necessary.
Mary, one of the more interesting moments, I think, during oral arguments came when Justice Douglas Barr questioned why opponents hadn't raised concerns during the routing proceedings. How significant was that exchange, did you feel, and what did it reveal about the court's thinking, perhaps?
So this is another area where things get a little tricky to explain. So to back up again, this dispute is over two different statutes that outline different procedures for reviewing projects like this, right? So there's the one that the plaintiffs say was wrong, that doesn't apply, and then there's the one that they say is appropriate and that the certificate of public convenience should have been heard under. But they also, I think, if I understood the arguments correctly, they say the route permit was considered under the right statute. So there were hearings on JETx's route that they think should have governed this whole thing. So Justice Barr's question was, if there were open hearings under that statute, even if it was just for like the routing permit, if they were held under that statute, would that not be the proper venue for the plaintiffs to go and then say, hey, this other thing didn't get a proper hearing under the law? Like, if this is the law pursuant to which this hearing is being held and you think something was done improperly procedurally under that statute, why not bring it up here? As far as what that might reveal about his thinking, I'm not exactly sure. I think it just kind of maybe shows the complexity of trying to figure out if things went awry procedurally and whether or not there's already a pathway in statute to correct that. I should probably also add, I did speak to some of the plaintiffs after the hearing, and they said they tried to bring up their grievances with how the hearing on their certificate was handled during hearings on their route application, and they said they weren't able to because they were told that was outside the scope of the route hearings.
Certainly trying to read the tea leaves of courts is challenging, to say the least. Jacob, many opponents, I think, from your reporting, feel they left the process feeling that they had never truly been heard. First, do you agree with that? And then beyond the specific issues raised, what was the broader frustration you heard from landowners throughout that debate?
Craig, I think you're absolutely right in that some of the landowner opponents of this project feel that they were not adequately heard throughout the public hearing process. The landowners that I've spoken to on this project feel that their concerns were not factored into the Public Service Commission's review process. And at least one landowner that I spoke to, Locust Wald, said that he did try and testify to some of those concerns during the public hearing process that he was aware of on the siting and the route permit for the project. He said that many aspects of his testimony were objected to, and he was not able to voice all of the concerns that he had in the process, in part because many of those concerns had already been decided through the certificate of necessity, earlier part of the process. And in general, this process appears to have left a sour taste in some landowners' mouths, that they have not adequately had a chance to participate in the decision making for a project that's going to affect their area and in some cases their land.
Mary, if the Supreme Court chooses to agree with the plaintiffs, do we know what that could mean for the project? Would it impact approvals that have already now been granted?
I'm not totally sure. I looked at the lawsuit, and the plaintiffs basically just asked, as I understood it, they asked the court to, if they get a favorable ruling from the Supreme Court, they asked that the review of the transmission line be halted until they figure out how to interpret the law.
Jacob, the commissioners suggested perhaps there are concerns now that are really policy questions for lawmakers. So do we have an idea of what kinds of issues could end up being debated during the next legislative session of the North Dakota legislature?
Yes, the commissioner's universal standpoint was essentially they enforce policy. They don't create or change policy. So on a lot of those issues that Commissioner Kringstead were saying was outside the jurisdiction of the commission, the setback requirements, the concerns about data centers, eminent domain, all of those topics have to go through the legislature if landowners and members of the public want change. So the 2027 legislative session could be interesting. In addition to the topics I just mentioned, I expect the question of local control to come up in some form or fashion during the upcoming legislative session. And just as a reminder for the audience, that is referring to how state regulations such as setback distances can preempt or supersede any rules put in place through local zoning ordinances and regulations, such as by townships, cities, counties, things of that nature. So I'd expect that to come up again.
Mary, beyond the legal arguments, is there anything that stood out to you as we kind of wrap up the conversation about the tone of the hearing and the concerns that were expressed by the residents that you spoke about earlier?
I think the tone I heard is sort of the same that Jacob mentioned earlier, that residents just keep emphasizing that they feel they didn't really get their voices heard. One thing that happened is the plaintiffs did ask the Supreme Court to have the oral arguments be held in person, which was denied. I'm not sure exactly the reason. It could have just been one of the parties couldn't appear in person, but that did make the residents feel like, oh, now here's another instance where we wanted something, like we wanted to be sort of involved, we wanted to be there, and now we feel like we didn't get that chance. And so
relegated to a Zoom call,
yeah,
essentially.
So it was held virtually, and a couple landowners I spoke to afterwards said, oh, it would have been nice if the justices could have seen how many of us would have shown up to be in the courtroom. That's not part of, I guess, exactly what the justice's job is. It's not part of their job to make that part of their decision-making process. To the plaintiffs, that would have made a difference, is what they were trying to convey, and so I do think that's important.
Jacob, do we know what milestones might be next for the project?
I think the big outstanding question is what Mary has been discussing, and that is the fate of this lawsuit. Outside of that, we have not, to my knowledge, heard a firm construction start date. So that'll be something that could come up in the next few weeks. And then looking further out, you've got the legislative session where this project and issues stemming from this project could very well come up. And in between, I think it's worth pointing out that this is one of several examples that I've observed across the state and that legislative committees are looking at and studying, because this is an example of developers and landowners and local communities that are in conflict and experiencing significant amounts of tension on projects that many in the state government feel are absolutely necessary for the future economic growth of this state and the reliability of the electric grid in this state. And finding ways to avoid that tension or resolve those conflicts is a big priority for a lot of state officials, a lot of state lawmakers. So I would expect to hear more on those conversations going forward.
The story is the proposed JETx transmission line. It's a proposed 92-mile-long high-voltage electric transmission line connecting substations near Jamestown and Ellendale. Visiting with North Dakota Monitor reporter Jacob Orledge and North Dakota Monitor contributor Mary Steurer about this issue that is not over yet. More to watch for sure. You can read their reporting on JETx in the North Dakota Monitor. Always free from subscriptions, always free from paywalls. Mary and Jacob, thank you so much for joining us on this A Closer Look with the Monitor.
Thank you.
Thanks for having us on, Craig.